which remains intact, does bar a putative biological person, a biological family in our society.
Did not the United States Supreme Court in 1989 affirm that principle in Michael H. versus Gerald D.?
I agree that it did, Justice Scott.
May I continue my line of questioning, Justice Scott? So then your view would be that the rebuttable presumption of paternity is only for a husband?
No, ma'am, not at all. No, ma'am, not at all. I would agree that it is for a male or female if they are a party to the marriage. If you look,
well, that would be a husband or a wife, wouldn't it? And the wife knows if she.
I'm sorry, I didn't hear you. I'm sorry, Justice. No, I didn't hear you say.
I do have laryngitis. I'm sorry.
I apologize. I thought you said just for a husband, and we're drawing a line based on male or female. I apologize. No, I do believe. Yes, ma'am. I do believe that it is solely for the parties of the marriage to have the ability to attack the paternity of a child born to an intact marriage.
So that would be only a husband
or a wife.
Well, that'd be tricky, but okay. Right. Now, next question.
Yes, ma'am.
Does this then, in your mind, because it may in mine, create a separate class of children with lesser rights than a child that might in fact be born out of wedlock?
Oh, no, ma'am. I view it directly opposite. I view that if we allow this case to go forward, that you are impugning upon alleged illegitimate children a separate right. What I'm suggesting is if you open this door, that we end up with a Hollywood type of situation where anyone can attack a family regardless, and that scar can't be erased.
But
and
have we not, counsel, ruled that as to illegitimate children, there is no difference in their right to inherit? And is it not the path of society today to recognize a child as a child, regardless if it is born within the marriage or without of it, so that we can equalize the status of every child? Would you not be, in fact, condemning this child to not have knowledge of his biological parent, or perhaps maybe inheritance rights or other matters that might be more in his best interest than the husband of the marriage could provide?
You are correct, Justice Noble. One would never know what a family will do once this kind of decision is made. But I argue that what you're talking about is trying to strike a balance. And in my opinion, Your Honor, the balance has got to come down on the side of protecting the families, keeping families intact in our Commonwealth. You see, from my perspective, as you are suggesting, the unlisted appellants in this case are all the children, all the families of this Commonwealth.
Counsel, if we expand the statutory definitions of parent to include a putative father in all cases, don't we open up avenues for even rapists to attack and taunt intact marriages? Because they would be the biological father.
Certainly would, in my opinion.
Would it not be better to let the trial court, however, hear evidence on that matter and make the decision rather than us making it at the appellate level?
I don't agree, Justice Noble. With all due respect to Your Honor, I think it's best that we set this, for the same reasons I said before, once that scar, or once that genie's out of the bottle, that scar is attached to that family. As Chief Justice Lambert himself quoted in SRD versus TLB, any emotional disruption of the parent-child relationship with a younger child will affect seriously to the detriment of the other children.
And are you totally confident that the husband of this marriage will not, throughout the course of this child's life, who he knows is the child of his wife's lover, not take it out on that child in subtle or obvious ways?
Certainly in the case at bar, having known my client, I can assure the court without hesitation.
You can't state that as a rule.
No, you're right, Judge, I can't do that.
Wouldn't the trial court be in a better position to make that judgment?
It certainly would be in a case-by-case basis. My problem with that, Your Honor, is that if we don't solve this problem for our Commonwealth, the balance, again, in my estimation, has got to come down on the side of the family in this case. It's got to be that we protect the integrity of the family, even if the best interest of the child may not be found in biology.
Counsel, you'll have 1 minute to wrap up.
Counsel, I have one other question. We have made a determination historically in this state through both the common law and it's been adopted by statute to, even let murderers off if necessary in criminal cases to protect an intact marriage. It's called the spousal privilege. Is that not great evidence of the historical value Kentucky has placed on intact families?
I would agree with you again, Justice Scott. I think it's correct. I think perhaps the Supreme Court of the United States said it best when it said, and I'd like to quote the court, imposing legal burdens on an illegitimate child is contrary to the basic concepts of our system that legal burdens should bear some relationship to the individual responsibility or wrongdoing. That, I hope, Justice Noble, addresses that there is no class.
Counsel, I believe Justice Abramson has a question.
Yes, Your Honor.
Good morning, Counsel.
Good morning. How are you?
First, what about Bartlett versus Callaway? And as Professor Graham points out in her treatise, historically in Kentucky, fatherhood or paternity has been about biology. And I know that you have cited to the court the California case, Michael versus Gerald, which I confess, having just arrived on this court yesterday, I haven't read that case recently. But my memory of it is that the California legislature had adopted a presumption that could only be challenged, and it said so in the statute, by the husband or the wife of the marriage. And in that case, you had a biological father who was trying to challenge, and the Supreme Court of the United States said, if California makes that legislative determination, that's their prerogative, and it doesn't impinge on constitutional rights. Now, so I've got two questions for you.
Okay.
First, historically, in Kentucky, I agree with Professor Graham from my study of the cases that fatherhood or paternity has always, except obviously in an adoption scenario, been about a biological connection. And if that biological connection is going to be severed, shouldn't that come from the legislature, as it did in California in Michael versus Gerald, when it said the legislature has made a determination that we are going to recognize the sanctity of marriage and that the presumption can be challenged, but only by a party to the marriage? So that's my question.
Your Honor, I think your reading of Michael H. versus Gerald B. is correct. I would argue to the court that the legislature has made that statement, and that it does through the presumption statute and eliminating the right of an interloper or outsider to attack the child born to an intact marriage.
So you would say Kentucky's already made the same determination that California has in the language of the statute?
Correct. And then I would agree that I would agree with the Supreme Court that where it said that the biological fatherhood does not establish a constitutional liberty interest under the Due Process Clause. And I'm sorry, was there another question?
No, I think you answered it, Counsel.
Thank you, Your Honor.
Thank you, Counsel. You'll have time for rebuttal.
Thank you, sir.
Mr. Helmers.